Give me dump!
Journalists that sometimes had to do stories in 2 minutes on the news frequently. Good afternoon. The Freedom of Information Act, or FOIA, should be one of the most powerful tools of the public and the press in a free and open society. Instead, it's largely a pointless, useless shadow of its intended self. Federal bureaucrats paid tax dollars to act on our behalf routinely break the law with impunity, as if treating public material as if it's confidential, secret information to be controlled by a chosen few. They withhold it from the public, its rightful owners, while sharing it with select partners such as corporations or other so-called stakeholders. In 2013, the Defense Department finally responded to a FOIA request I'd made in 2003. Too late to be of use for the news story I was working on back then, 10 years before. For some perspective, my daughter was 8 years old when I made the FOIA request. By the time I got a response from the Pentagon, she was going off to college. Last October, I filed a FOIA request when CDC was not forthcoming about the epidemic of enterovirus EVD68, possibly linked to the deaths of 14 children in the U.S. and the paralysis of 115 children. In December, long past the supposed 20-day response time allowed under FOIA, I asked CDC about the status. CDC answered incredibly that they were just far too busy with the Ebola crisis to process my FOIA. But even now, with the Ebola crisis excuse gone, CDC still hasn't provided a single page of enterovirus information 8 months after I asked. Filing a lawsuit to force the government to comply with FOIA law takes too much time and money, and the agencies still play the delay game. In court, the Justice Department, one of the worst FOIA offenders, spends our tax dollars defending violators in their effort to keep public documents secret. In one lawsuit I filed, the FBI spent months repeatedly claiming that it didn't have information that it had previously acknowledged in writing that it did have. I also filed a lawsuit for healthcare.gov material in 2012. Apparently, the government didn't even bother to start looking for it until I filed a lawsuit. Only now in 2015 are they beginning to do so. The documents provided so far are redacted beyond reason. In 2014, when the State Department finally sent some emails responsive to a 2012 request I'd made, just about everything was redacted except the address line. It should come as no surprise that the federal agencies often treat Congress with the same disdain and lack of transparency. They guard and redact information Congress requests as if Congress is a foreign enemy rather than representatives of the rightful owners of information. When pressed to provide material to Congress, federal officials often exert dictatorial control, creating strict terms and rules such as only allowing review of the material during certain times in very special rooms, all under the watchful eye of federal agency minders. This is not transparency. The FOIA process is improperly politicized. Federal agency press flacks and politicians intervene to withhold potentially embarrassing information. FOIA law does not permit this political intervention, but it happens all the time. Federal agencies increasingly employ new tactics to obfuscate and delay. They say they don't understand a FOIA request. They claim it's too broad. They say a search would be unreasonable. When they do provide a sensitive document, they redact nearly everything using exemptions such as B5, deliberative process, which has become so ridiculously overused it has earned the nickname withhold it because you want to exemption. These are some recent documents I received from Department of Health and Human Services with some B5 exemptions on there. Federal agencies claim they lack funding and staff. With all due respect, Congressman Cummings, you're probably very correct in much of that. But I've also seen that they create some of their own backlog by unnecessarily requiring even the simplest request to go through the onerous FOIA process when it's not necessary. And when a court finds a federal agency violated FOIA law, penalties are almost never imposed, and if ordered to repay the plaintiff's legal fees, the government does so with your tax dollars, meaning there's no deterrent to stop the bad behavior. In other words, they're using our money to prevent us from seeing our own documents. In short, FOIA law was intended to facilitate the timely release of public information, but instead federal officials have perverted it and now use it to obfuscate, obstruct, and delay. The system is not broken by accident, it's by design. In my view, the only thing that could make FOIA work as designed would be meaningful criminal penalties for violators. Thank you.
Thank you. Mr. Leopold, you're now recognized.
Chairman Chaffetz, Ranking Member Cummings, and members of the committee, thank you for inviting me to testify today about the Freedom of Information Act. My name is Jason Leopold, and I'm an investigative reporter at Vice News. Sorry about that. I aggressively use the Freedom of Information Act in order to find out what is taking place behind the scenes within the federal government. I write long-form investigative news reports, many of which showcase the documents I have obtained through FOIA. And I also maintain a FOIA blog at Vice News called Primary Sources. My FOIA work has been cited by the Second Circuit Court of Appeals and contributed to the panel's decision last year to order the Obama administration to release to the New York Times and the ACLU the Justice Department's targeted killing memorandum. Documents I have received through FOIA over the past year include a Justice Department white paper that explains the legal justification granted to the CIA to kill a U.S. citizen suspected of being a member of al-Qaeda. An invoice showing that Guantanamo officials spent $300,000 on force-feeding formula while denying the existence of a mass hunger strike at the detention facility. And emails showing the White House's interference with the FCC over net neutrality. Information obtained through FOIA is critical to our democracy because it helps citizens learn what their government is up to. Unfortunately, delays in obtaining responsive records remain a significant problem for requesters. I have submitted thousands of FOIA requests to dozens of different agencies, and in my experience, fewer than 1% of my requests have been decided within the time frame required by FOIA. I routinely experience delays of several years in response to my FOIA requests. For example, the Office of Legal Counsel recently informed me that it would likely not complete the processing of my FOIA request for emails until December 31st, 2016, due in part to the agency's backlog. FOIA requests are sometimes delayed and politicized at the Pentagon because the agency has a policy that calls for certain FOIA requests that may generate media attention to first undergo an internal review and receive department-level clearance before a response is issued and/or records are released. My FOIA attorney, Ryan James, successfully fought back the State Department's attempts to delay the release of Hillary Clinton's emails until next year by securing an agreement that will see monthly releases of those documents, and that took place last week. But delayed responses to FOIA requests are a significant problem for investigative journalists. Information becomes less newsworthy with the passage of time, and it leads to a perception that FOIA is not a useful tool. FOIA does provide for expedited processing in certain circumstances, but I have found that agencies take a narrow view of what circumstances merit expedition. Even when expedited processing is granted, the process still moves slowly. For example, I submitted a FOIA request to the Department of Justice on September 5th, 2014 for records relating to the department's investigation of allegations that the CIA had accessed Senate Intelligence Committee staffers' computers without authorization. When I did not receive a prompt response, I immediately filed a lawsuit. Expedited processing was eventually granted, but the agency sought and obtained approval from the court to delay the release of any records until January 29, 2016. It is often the case that the filing of a lawsuit against an agency catalyzes the release of documents. And I'm fortunate to have a prominent FOIA attorney, Jeffrey Light, representing me and Vice News in more than a dozen lawsuits currently against various government agencies. But let me give you a specific example of how the FBI maintains a deliberate policy of violating FOIA until a lawsuit is filed. Under Exemption 7A, an agency may withhold records or information compiled for law enforcement purposes, which could reasonably be expected to interfere with enforcement proceedings. Congress deliberately chose the words records or information when it amended Exemption 7 in 1974. The FBI's standard practice, however, is to categorically apply this exemption for all investigative files, rather than determining which records or information would interfere with law enforcement proceedings. This is a clear violation of FOIA. Doubtlessly aware of this fact, the FBI has never defended its position in court. Instead, when a lawsuit is filed, the FBI conducts a new review applying the proper standard. A federal judge recently stated that, quote, Because the court has doubts about whether the FBI conducted the required review at the administrative stage in this case, it will remind the Bureau of its obligation to perform such reviews in the future. Despite this reminder from the court, the FBI has continued to deny my requests because the records requested are located in an investigative file. Congress and the courts could not have been clearer. It is a violation of FOIA for the FBI to interpret Exemption 7A the way it has. Yet the FBI continues to be in routine and flagrant violation of the law. I have many more examples to share with this committee. In sum, FOIA can be a valuable tool for investigative journalists, but only when it functions effectively. Thank you for your time and attention to this important matter, and I look forward to answering your questions.
Thank you. Mr. McCraw, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ranking Member.
I want to make sure that microphone's, there you go. Thank you.
Thank you, Mr. Chairman, and thank you, Ranking Member Cummings and members of the committee. I appreciate the opportunity to testify about the Freedom of Information Act. As an Assistant General Counsel at the New York Times, I provide legal counsel to the newsroom. I'm very familiar with the problem that delay presents for our journalists as they seek information. Last year, I filed 8 FOIA lawsuits on behalf of the Times. Much of that litigation was driven not by actual disagreement about legal issues, but in response to unacceptable delay by agencies. In other words, we find ourselves compelled to litigate simply to prompt agencies to act upon a request. Let me provide one recent example that shows how wasteful and inefficient all of that is and why reform is needed. Late last year, the Times made a simple FOIA request to the Department of Justice. We wanted to know how much money the DOJ had spent paying the legal bills of FOIA requesters in the Southern District of New York. FOIA permits the courts to award attorney's fees in FOIA cases where the requester wins. We simply wanted to know in a single judicial district how often that happened and in what amounts. It was a straightforward request about a budgetary matter. No FOIA exemption could possibly apply, but weeks passed without a response. Over a 4-month period, we repeatedly contacted the FOIA officer handling the request. We called that office more than 10 times and left messages. Almost all of those cases went unreturned. Finally, we filed a lawsuit out of frustration. At that point, the U.S. Attorney's Office was required to become involved. An assistant U.S. attorney took on the task of finding out what was going on in the FOIA office, had our request moved quickly along with court deadlines looming, and succeeded in getting the documents released to us. In short, an assistant U.S. attorney ended up doing what the FOIA officer should have done in the first place. Forcing requesters to litigate to get a response is a waste of government resources. But more than that, a citizen's right to get information released in a timely fashion should not turn on whether the citizen is fortunate enough to have the resources and know-how to sue. There is much that needs to be done to fix FOIA, and I urge the House to move forward with the reform bill, which takes important steps towards empowering OGIS, limiting Exemption 5, and encouraging the use of technology. But I want to focus today on something very basic. What can be done to get agencies to respond in the timeframes dictated by law? Congress, in enacting FOIA, set a response deadline of 20 business days. While statistics show the response times have improved, we know from actual experience that responses from many agencies take months or years. In the documents we submitted with my testimony, we include a letter from an agency that has sat on a request for nearly 4 years and now wants to know whether we're still interested. Our written submissions document some specific issues relating to today. Let me just briefly highlight 3. First, much of the delay appears to have little to do with the nature and complexity of actual requests, but instead results from a culture of unresponsiveness. Some agencies are consistently good, while others show little sign of improvement year after year. As requesters, we are not in a position to know what the root causes of delay are, whether a lack of resources, poor work performance, inadequate training, or something else. But we do know 2 things. First, Congress, after weighing all the competing considerations, set specific deadlines in the law. Second, the leaders of many agencies are permitting those deadlines to be ignored by staff. In the end, this is a management issue, and those in charge of agencies should be held accountable for figuring out what the problem is and fixing it. Second, delay frequently occurs because agencies decide to refer a request to another agency. This happens when the second agency is a stakeholder in the information sought. Referral may make sense as a policy matter, but few rules govern the process. The referring agency lacks authority to demand a response from the second agency or set a deadline, and the requesters are left on the sidelines. Much clearer rules and deadlines are needed. Third, FOIA requests often seek information that has been submitted by companies to regulatory agencies. Disclosure of this information is vital to citizens so they can monitor whether regulators are doing their jobs and see whether companies are being treated fairly. But in response to such FOIA requests, agencies frequently take the position they need to consult with the submitters. This process becomes a source of endless delay. In the documents we provided to the committee, we include an agency response letter saying it would take 15 years to finish the consultation and respond to our request. Not surprisingly, when we sued, a federal judge found that was simply not the case and ordered the release of the information. In conclusion, there are a host of reforms we're pursuing, as we see in the House bill, but taking steps to ensure that agencies respond in the time periods that Congress saw fit to establish should be an essential part of any reform. Thank you for inviting me to testify and for taking on this important issue.
Thank you. I appreciate that. Ms. Goodman, you're now recognized for 5 minutes. Microphone. Oh, yeah, thanks.
I just want to thank you, Chairman, and thank Ranking Member Cummings and the rest of the members of the committee. I'm really glad to be here today with so many journalists who I very much respect. And the fact we've come here at all represents a stark departure from our usual routine as journalists. While we may frequently be found writing about hearings such as this, as a rule, we try not to participate in them. Our mandate to remain objective as journalists demands that we stay well above the political fray and cover stories from all angles, notwithstanding whatever our privately held opinions might be. The larger problem that we face, though, right now is that our role of objectively collecting and reporting the facts has been increasingly and aggressively blocked by those who would seek to separate the journalists as well as members of the public from the information that we are lawfully entitled to. In my job as a senior writer and finance editor at Newsweek, I've been surprised by the number of government agencies that will stonewall even the most basic requests for information that readers and the public have a right to. There are no Washington editors here today from any of the big newspapers, and the reason why, because I spoke with them, is that they are concerned about a chilling effect for even speaking out on this. They are concerned about the consequences of coming here. This, I think, speaks to the seriousness of this matter. Collectively, the journalists who are here have covered major events in this country for decades and have dealt with plenty of blowback, but we have never before seen so many agencies that have turned themselves into veritable black boxes where information goes in and it does not come out. What we're now witnessing in terms of obstructionism and obfuscation is truly unprecedented in our careers. The issues surrounding the Freedom of Information Act, in my opinion, are symptomatic of a much wider problem. Our job, which is to inform the public about issues crucial to our democracy and to the national discourse, relies on our ability to gather and check facts in a timely fashion. It should be understood that the job of journalists is to have no agenda other than to get answers to important questions for our readers, and we aren't just answerable to them, we are members of the public. Last I checked, our government works for the public and is paid for by the U.S. taxpayer. You'd think that our public service mission as journalists and the government would have somewhat symbiotic relationships, but as we know that we don't. The fact we're even here speaking to the members of the House is proof of our widely held notion of a government accountable to its people is broken. While my colleagues are much more accustomed to problems relevant to the Freedom of Information Act than I am, I'm here to offer broader context about what we face every day as we try to do our jobs. To be completely honest, I come from a generation of journalists who were told upon entering the newsroom, if you want to know what you're going to be writing about in 3 years, file a FOIA. So if I want to write about something in less than 3 years, I don't file a FOIA. The long waiting games, heavy redactions, and lack of accountability, and the culture of concealment that seems to pervade the FOIA process also carries over into all aspects of what we do, especially when we're dealing with government agencies. Once upon a time, you could call a government agency and talk to someone with a real first and last name. You could get their contact information without fighting through people for it. You could tell them what you were writing about and set up an interview with someone knowledgeable at the agency who could talk to you. Sometimes they would have no comment, which is fair enough. But everyone knew who they were dealing with, and the process was as honest as one could expect it to be. In other words, there was a modicum of responsiveness and accountability. These days, when I call a federal agency, what I'm dealing with can only be compared with an offshore call center with a constantly rotating cast of characters answering the phones who are trained to not give their names, who can tell you nothing about who is knowledgeable on the topic about which you're writing, and who urge you to email a generic info@government.gov sort of address, which has no name on it, and as all journalists know, is the kiss of death. I don't think this is the fault of the staffers. In my opinion, most of the staff at these agencies are not being empowered by their superiors to have even rudimentary exchanges with journalists. The next time you read a news article that involves a government agency, count how many times an actual person with a name has an actual quote from that agency that does not come from an already published comment or congressional testimony or a press release or a press conference. You'll see that quotes from these sources with full names from agencies are rarer than hen's teeth. This is because the environment we're operating in, journalists will not be able to talk to anyone unless we agree to not name them, or they will ask to remain anonymous while contributing to our stories. In these cases, the agency or staff member will comment only on condition that they are not identified, effectively attempting to make it impossible for readers to know who's feeding them this information. And we, the journalists, are expected to be the enablers and stewards of this cowardly process I find to be the opposite of what journalism is for. One example. While investigating high-frequency trading last year and whether it was disrupting our markets, as finance editor for Newsweek, the U.S. Securities and Exchange Commission repeatedly told me that I could not quote its market experts even after arranging interviews with them and conducting extensive conversations with them and agreeing to allow them to check their own quotes. This government agency is tasked with overseeing the nation's stock markets, and yet it also informed me that while I could use the information it gave me, I could not say where I had gotten it in my story. In other words, I was to hide the fact I had gotten this information from the SEC and expected to present it to the public as incontrovertible facts. Ethically, journalists can't agree to such terms unless under rare circumstances, usually ones entailing security or protection of an individual, not large government agencies. But these agencies want this kind of special treatment every day, and that is as a starting negotiation condition. In the case of the SEC story, I didn't agree to the terms, and as a result, an SEC staffer asked to speak with my editor immediately. The message was clear that if I did not do as I was told, the situation would be escalated in a way that might be problematic for me. My editor was not amused, and days after we went to print with the story, the SEC announced an investigation into high-frequency trading disrupting U.S. markets. In the past year alone, I've worked with around 24 government agencies that have wanted to dictate to me how to write my stories, what I can say and cannot say, and they seem to think this is entirely reasonable when in fact it is quite extraordinary. If I don't agree to the terms, the result will be waiting days, weeks, or getting no answers at all to questions. While one might chalk this up to a basic lack of media training among these agencies, it is curiously lacking in exactly the same way, with the same tendency towards zero accountability, anonymousness, and it's getting worse. These issues are not just ones of gamesmanship in the form of delays and denials of critical information, but a desire on the part of our agencies to remain in the shadows while anonymously influencing the news received by the voting public. It is my hope that by appearing today, the House might consider taking steps to place such standards that would restore accountability. To directly address what can be done regarding FOIA and the broader problems that I speak of, Congress should consider legislating an enforceable set of core standards by which Americans can seek and receive information in a timely fashion from identifiable sources within the government in response to their questions, rather than the cloak and dagger games that we now see. Until such standards are imposed and enforced with real consequences, I think these games will continue. Lastly, if you're wondering if I expect there to be consequences for my being here and saying this today, yes, I do. But I believe if we don't stand up and speak in one voice as journalists, that our jobs will only get harder. Thank you for your time, and again, thank you for having me here.
Thank you, Ms. Goodman. Mr. Anderson, you're now recognized for 5 minutes.
Thank you, Mr. Chairman and members of the committee, for allowing me to come and speak here today. I agree with the chairman and with my colleagues that government transparency and its obverse, government secrecy, are among the most important problems that we face today, both this body and our country. The guarantee of freedom of speech and of the press and all the other freedoms that we have enjoyed for 240 years means little without freedom of information. If we do not know what our leaders are doing in our name, how are we going to hold them responsible, accountable? How can we know which leaders to choose? How can we claim to have a government of the people, by the people, and for the people? Yes, there are certain things we should not know too much about. The movements and strategy of our armed forces in wartime, for instance. But such cases arrive seldom. So why is our government and its agencies currently protecting millions of individual documents, hundreds of thousands of actions and decisions made by our elected and appointed officers, at the cost of somewhere upwards of $11 billion a year and increasing drastically? Yes, I know the world is a dangerous place. I know that 2,700 people were murdered at the World Trade Center on September 11, 2001, and hundreds more in attacks on embassies and individual Americans around the world since. But I also know through experience and through research that the vast majority of those millions of secrets have nothing to do with terrorism or our national security. Instead, they often involve automatic decisions by the horde of bureaucrats who have the authority to stamp top secret on the flow of papers that cross their desk. Or just as often, some minor functionary trying to protect himself or herself from political or personal embarrassment. How do I know this? Well, when I came home from Lebanon, I was given a generous fellowship at Columbia University by the Freedom Forum, so my wife and I could write a book about our experience. We decided to ask, under the Freedom of Information Act, for any information on my kidnappers that might be held by the various intelligence agencies, the CIA, the FBI, the NSA. In all, we requested responses from 13 government agencies. As you know, FOIA sets time limits and parameters for official responses to that kind of request, as well as procedures for appeal, ultimately to a court of law. After 2.5 years of messing about with denials and denials of appeals and outright failures to respond, I finally took advantage of that last provision and filed suit in U.S. District Court in Washington. Included in the legal submission was the initial response from the DEA, which was made long after its FOIA deadline had expired, but informed me that they could not furnish the information I requested because it would violate the privacy rights of the individuals concerned. However, if I was able to get a signed, notarized release from my former hosts, they would be happy to cooperate. I was not greatly interested at the time in finding my kidnappers again and asking them for permission to peruse their files. Eventually, I began getting actual documents. Most were heavily redacted, including one that had only the title left, with about a dozen pages following it completely blacked out. And so we fought on for 4 years, at the end of which, in accordance with repeated judicial orders, I had dozens of boxes of files to look through to try to understand the events that had engulfed me and my family. I read them all carefully. They included copies of my own stories for the AP, which had already, of course, appeared in thousands of newspapers, copies of publicly available reports stamped confidential, and masses of irrelevant paper or discussions of diplomatic faux pas or less than diplomatic comments someone had made about foreign leaders, and so on. So the government spent millions of dollars and 4 years of effort trying to protect secrets, not one of which concerned actual security interests of the United States. During this period, the late Senator Daniel Moynihan conducted at the President's request a 2-year study of government secrecy. You may remember it. He concluded in his 1995 report that the U.S. had fallen into a culture of secrecy which had become dangerous to our democracy. Senator Moynihan, a great statesman, a brilliant mind, and a personal friend, said this: "Excessive secrecy has significant consequences for the national interest. when, as a result, policymakers are not fully informed. Government is not held accountable for its actions, and the public cannot engage in informed debate. Secrecy is a form of regulation, the senator said, and while we're all familiar with government overregulation, the public cannot know of overregulation when the regulation is kept secret from them. Senator Moynihan also noted that while the then-controlling presidential finding authorized 20 officials to use the top-secret classification, meaning concerning information the disclosure of which could be expected to cause grave harm to our national security, some 2 million officials and 1 million private contractors had been given derivative authority to use that officially highest classification. 3 million people stamping top secret on the flood of paper crossing their desks. The Moynihan Commission recommended some changes in the law, including an Office of Declassification. Nothing was acted upon. In fact, when President Clinton ordered a mass declassification of documents from World War II and before, he was largely ignored by the bureaucrats who run the system. By the way, the oldest known classified document in the system at that time was a report on troop movements in World War I. As far as I know, it's still classified. In 2006, the CIA and other agencies, in an operation that was itself classified, pulled 55,000 documents out of the public domain at the National Archives and reclassified them. I'm going to presume they're still doing that. And so we come to the opening of the Obama administration. On Inauguration Day, the new president announced his commitment to a new era of openness and transparency. My administration is committed to creating an unprecedented level of openness in government, he said in a message to all government agencies. Today, reporters describe this administration as control freaks and the most closed they've ever covered. The Obama administration has prosecuted more whistleblowers than any other and used the Espionage Act more often than any other administration to prosecute reporters' sources. It has also spied on reporters and even their parents. The result of all this is inevitable, I believe. We now have a society in which large areas of government decision and action are routinely kept from the public. Think of Abu Ghraib and the torture of prisoners, official and unofficial. Think of massive spying on American citizens, whose phones, computers, vehicle movements, even bank accounts can be monitored without their knowledge. And if they have the ability, what makes you think they won't use it? Oh, and by the way, I'm sure the members of the committee realize this includes you. When you call the head of the NSA in here and ask him, and he says, no, we don't spy on members of Congress, are you going to believe him this time? Our fear, heightened by the war on terrorism, is overwhelming the system of government that has served us for 240 years. Half of the Bill of Rights is now regularly ignored. Officials of our own government agencies seem to violate the Constitution at will and with impunity. Our senior intelligence officials blithely lie to you and to the American people in the name of security. And we can do little because we know little. I believe that young Mr. Snowden should not be hiding in Moscow, and poor Private Chelsea Manning should not be serving a long prison sentence. Yes, they broke the law, but they did so in accordance with their conscience, which told them that what they were seeing was wrong. They should be here in Washington wearing black ties and receiving awards. Because of them, we are now having a public debate over serious issues we would not even know about. We need this debate. And more than that, we need some action that will return us to the principles we have held to since the founding of the United States. We need to control our fear and control our government. Thank you.
I push that.
Thank you,
button
Mr.
there.
Chairman, for allowing me to testify on behalf of Judicial Watch. Transparency is an important issue to the American people. We're a conservative group, but we're nonpartisan, and we have over 360,000 active supporters. And there are a few more widely supported groups in the country than Judicial Watch. And obviously, our focus is on the Freedom of Information Act. We're the most active requester, most active litigator, without a doubt today. And we've used the open records laws to root out corruption in the Clinton administration and to take on the Bush administration's penchant for improper secrecy. You may recall we sued the administration of President Bush all the way up to the Supreme Court over the Cheney Energy Task Force. We've been around for 21 years, but I can tell you our government is bigger than ever, and it's frankly the most secretive in recent history. President Obama promised the most transparent administration in history, but federal agencies are often black holes in terms of disclosure. We filed nearly 3,000 Freedom of Information Act requests with the Obama administration, and our staff attorneys have been forced to file around 225 lawsuits in federal court against this administration. Overwhelmingly, these lawsuits are just designed to get a yes or no answer from the administration. And administratively, agencies have built additional hurdles and stonewalled even the most basic FOIA requests. The Obama administration's casual lawbreaking, and it is lawbreaking, when it comes to FOIA, is a national disgrace and shows contempt for the American people's right to know what their government is doing. You know, Thomas Jefferson, the Founding Fathers, all thought transparency was important. Jefferson said, if we are to guard against ignorance and remain free, it is the responsibility of every American to be informed. And FOIA increasingly is not working in that regard. Transparency is about self-government. If we don't know what the government is doing, how is that self-government? Frankly, how is it even a republic? Now, we have this transparency crisis here in Washington, D.C. The government's doing more than ever, but is even less transparent. Never in our history has so much money been spent with so little accountability. Frankly, all of Congress should focus on government reform and oversight instead of assigning it to just one or two committees. Americans are rightly worried that they're losing their country. We have the forms of democracy, elections, campaigns, votes, political fundraising, ads. But when Congress authorizes $1.5 trillion in spending after just 3 days of debate, and when the executive branch won't tell you much unless you're willing to make a federal court case out of an issue, frankly, that isn't democracy, and it certainly isn't self-government. But FOIA shows that there is a way forward out of this transparency crisis, and it's a corruption crisis as well. We've shown that one citizen group using the FOIA and independent oversight can help the American people bring their government back down to earth and under control. And Judicial Watch obviously has succeeded in uncovering documents that have been denied to Congress. On Benghazi, it's been a little over a year since Judicial Watch uncovered a declassified email showing that then White House Deputy Strategic Communications Advisor Ben Rhodes and other Obama administration's officials, not intelligence officials, put out the talking points used by Susan Rice, that the big lie that the Benghazi attack was rooted in an internet video and not a failure of policy. Now there's a select committee because of those disclosures. A select committee, to put it charitably, doesn't seem to be getting much of anywhere. And Judicial Watch's litigation continues to be the go-to place for information about what's going on in the Benghazi scandal. The IRS scandal. Judicial Watch litigation forced the agency to admit that Lois Lerner's emails were supposedly lost. And it was Judicial Watch's litigation that forced the IRS to admit that her emails were not actually lost. And only Judicial Watch uncovered the troubling revelation that the Obama IRS and Justice Department were collaborating on prosecuting the same groups that the IRS had lawlessly suppressed. We're still getting screwed around by the IRS. We just filed today a filing that the IRS, updating the court on the IRS's machinations with Lois Lerner's lost emails. They told us there were no tapes. It turns out there were tapes. They made us go through all sorts of hoops to figure out where the lost emails might be. They made the court go through all sorts of hoops. And then it turns out that the Treasury Inspector General had this information and had these tapes. They had turned over those tapes one day after they had been requested, the IRS to TITCA. They didn't tell us that, and they made us go through this fight with them over where these lost emails would be. They knew where they were. And then once TITCA found the emails that were lost, IRS said, well, they're not subject to FOIA. They're TITCA's records, not the IRS's records. Then a few weeks ago, they said, oh, we got some emails from TITCA, so now there are records, and we'll get to them when we get to them. Really outrageous conduct. And then, of course, we have the most egregious violation of federal transparency law since FOIA was passed 50 years ago. And that is Mrs. Clinton's use of a secret email account to avoid disclosure under the Federal Records Act and avoid disclosure under FOIA. And when you have the State Department agency tell Judicial Watch they looked for records and they couldn't find anything. And groups like Judicial Watch end their lawsuits based on no records being found. That was a lie. They didn't look for the records. Mrs. Clinton was head of the agency, and she had a legal responsibility to maintain those records. And there is criminal liability already for failure to maintain those records. It's called concealment. You can't conceal records. You can't take them away if they're federal records. And that was what Mrs. Clinton did. And there is a long-standing law that prohibits that. And certainly in the least, that should be subject to criminal investigation independently. And I'll just finally close. Obviously, Congress is not subject to FOIA. It ought to be. The courts aren't subject to FOIA. It ought to be. But the problem is the executive branch is avoiding FOIA. FOIA reform is important, and we support serious, impactful legislation, and we encourage you to keep on working on that, and we'll work with you as appropriate. Thank you for your time.
Thank the gentleman. Ms. Mitchell, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, members of the committee. Thank you for having a hearing on this really important topic. I have, in my testimony, explained my experiences with FOIA with a number of my clients over the past several years, nonprofit, grassroots citizens groups. I want to focus today on just one of those experiences, and that is with the IRS and Treasury on behalf of the Tea Party Patriots. When the IRS and Treasury issued its 501c4 regulations, which would restrict and allow the IRS to govern free speech and political activities of 501c4 organizations, regulations that were developed in secret, that were not included on the plan for rulemaking that all federal agencies are supposed to publish regularly, and were released the day after Thanksgiving on Black Friday, November of 2013, we wanted information about where did these regulations come from? What were they about? How were they developed? So on behalf of Tea Party Patriots, in early December 2013, we filed FOIA requests with the IRS and Treasury seeking information and the documents related to the development of the regulations. The Department of Treasury wrote back and said, we're going to invoke our 15-day automatic extension. And that was all we ever heard from the Treasury Department until we sued them. The IRS wrote back and said, we're invoking our 15-day extension. But we're not going to be able to answer within the statutory period. We'll answer your FOIA request April the 7th of 2014. April the 7th, I get a letter saying, we're not going to be able to answer your FOIA request as we promised. You'll need to give us until July the 2nd. So I called the woman who sent the letter and said, tell me what the progress is. How are we doing? At which point she said, well, you know, I process the requests and I send them to the appropriate people within the agency, and then I don't ever hear anything back. I said, you've never heard anything back? She said, no. I said, well, how did you come up with these dates? She said, well, I was estimating. I said, so you made them up? She said, basically. So 1 week later, we filed a lawsuit in federal court here in D.C., a FOIA appeal. And we reached an agreement with the Department of Justice where they would provide monthly rolling productions from the IRS and Treasury. And I have brought the binders with me, if you would like to see them. And this is the most recent, these are the most recent production, which I got yesterday, day before yesterday. It is you can't see it, page after page of documents that are either totally or partially redacted. All this, ladies and gentlemen, this is the deliberative process privilege in action. We have not received one substantive document. In all of these binders, we have received, we did agree with the Justice Department that they would produce a Vaughan Index, which is like a privilege log. So we do have a list of thousands of pages of documents they haven't produced at all. And the pages they have produced are either totally blacked out or partially blacked out such that all significant information is removed. So what we have really effectively learned is that the deliberative process privilege has completely subverted and destroyed the purpose of FOIA. And the Tea Party Patriots have spent tens of thousands of dollars just to try to understand regulations which were withdrawn. So I have a question as to why the deliberative process privilege would still apply to regulations that have been withdrawn. But we now know they're still working on redoing them, but we're asking about the last set. But the point is this. We have spent my client has spent tens of thousands of dollars. We spent many, many hours trying to get information to which we are entitled, and all we've gotten are these binders full of redacted documents. And so I have this to say, which is that FOIA is completely broken. What has happened is that the courts and the agencies have rendered it essentially meaningless. And so I have 3 recommendations. Number 1, this legislation that is pending in the House and the companion bill in the Senate needs to have one provision added. Congress should eliminate the deliberative process privilege. It is the deliberations of the agencies and the process by which the decisions are made that the people have a right to know about. That's the basic information that we seek. And so Congress should eliminate, by statute, just X out the deliberative process privilege. And number 2, I also recommend that there have to be penalties that are imposed for individual government employees and agency heads who fail to comply with FOIA. And number 3, Congress should take all of the money. I've heard the conversation about, well, you know, we cut their budgets and all. Let me tell you, this took a lot of extra work. It would have been a lot less expensive for these for the IRS and Treasury to just copy the documents and send them to us. But going through and redacting takes a lot of extra processing time. But I would say this, Congress should go through every federal agency and take the money that is now spent, the tens of millions of dollars now being spent for the public affairs offices who put out press releases, who tell us propaganda, whether it's true or not, that they want us to know, and reallocate all of those funds to FOIA processing. And then I think Congress should keep a scorecard and should know how agencies are doing in terms of responding to FOIA and should take that into account at appropriations time. So I would say this, only Congress can fix FOIA. Nobody else can fix it. Congress needs to revive FOIA, to breathe life back into the system, and to make it the Transparency Act that it was intended to be almost 50 years ago. Thank you for this opportunity to testify.
Thank you. Mr. Jones, you now recognized for 5 minutes.
Mr. Chairman, distinguished members of the committee, thank you very much for this opportunity. At the National Security Archive, we've filed more than 50,000 FOIA requests, conducted 14 government-wide FOIA audits that have displayed the inner workings or non-workings of over 250 FOIA shops. Our White House email lawsuits against every president from Reagan to Obama have saved hundreds of millions of messages and set a standard for digital preservation that the rest of government has not yet achieved. The key point I'd like to convey to you today is that the tremendous promise of the Freedom of Information Act, a tool that citizens can use to efficiently and effectively gain access to records produced by the government, has not been fulfilled. Unlike some in the previous panels or others, I wouldn't say it's broken. One only look to the National Security Archive's website and see the millions of pages of documents we've got declassified that have rewritten history and help write policy, or look at Jason Leopold's scoops. But the Act has certainly not fulfilled its promise. So today I'd like to present 3 of the largest barriers to FOIA requesters and how I believe the committee's legislation that, thank you for already passing, will already help these barriers. But before I begin on barriers, I have to note that there actually are dozens of exemplary FOIA agencies and hundreds of star FOIA professionals who really do have transparency in their bones and placed requirements of the FOIA above bureaucratic concerns and fear of government and fear of embarrassment, To these agencies and FOIA specialists, thank you. I guess in this case the reward for competence is inconspicuousness. But back to barriers. The first negative interaction a FOIA requester experiences with an agency is over fees, because many agencies have adopted a strategy of using the specter of high FOIA fees to deter people from making legitimate requests. This practice is fiscally unnecessary. FOIA fees cover just less than 1% of the cost of implementing FOIA, and it's also often illegal. The 2007 FOIA amendments make it very clear that any time an agency misses its FOIA deadline, it can't charge most FOIA fees. But many agencies, with the very troubling support of the Department of Justice, have improperly skirted the crystal clear intent of these provisions so they can use sticker shock to head off requests without processing them. Fortunately, both FOIA bills include language which should prohibit these hijinks once and for all. The second barrier, improper withholding of information. This Sunshine Week, White House spokesperson Josh Earnest repeated a Department of Justice talking point touting a 91% FOIA release rate. But this figure is extremely misleading. DOJ numbers ignore 9 of the 11 reasons FOIA requests are denied. The actual FOIA release rate is just over 50%, and many of those partial releases, you see them right here. Reams and reams of wholly blacked out pages are classified as partial and go into the DOJ's figure as such. More startling, the AP's recent finding that when challenged, government agencies admit they wrongly withhold information almost a third of the time. As this committee well knows, the most oft-abused exemption is Exemption 5, the go-to exemption that agencies use to withhold embarrassing, incriminating, or even burdensome to process documents. Happy to talk more about that later. But I do laud both of the B5 fixes in the bill. They're very good. The third barrier is the inability for agencies to leverage technology to improve FOIA and record-keeping procedures. Because of this, your bill's language instructing agencies to make information public to the greatest extent possible through modern technology is very welcome. FOIA shops are far behind the private sector utilizing e-discovery and automated front-end redaction tools to process requests, and they're also far behind making their releases digitally available to the world. Just 40% of agencies follow the intent of the 1996 e-FOIA amendments by routinely posting documents online as they're released. Now, the good news is there are some good examples. The FOIA online agencies post documents as a matter of practice, and the Department of State, for all of its other FOIA and record-keeping problems, does have the best online FOIA reading room that posts all of its releases online. Email. Today, right now, federal agencies are still not required to digitally preserve their emails. The deadline is not until December 2016. Until then, federal employees will continue to be allowed to select themselves which emails they believe to be federal records, print them out, and file them in a box. As long as this practice is allowed to continue, it is unrealistic to expect that any federal agency will properly search emails in response to FOIAs, or that their email preservation rate will be any better than the State Department's 0.006%. Department-wide. The final overarching point I'd like to make is that the root cause of these problems that you've heard today is a lack of an independent, robust organization that monitors and enforces FOIA compliance throughout the federal government, a FOIA beat cop. The current process of encouraging agency compliance, that's what the DOJ does at the same time, it defends agency withholdings and abuses, and reviewing agency compliance, that's what OJIS does, after it gets OMB approval to review, are clearly not establishing agency compliance with the FOIA. My fear is that without robust enforcement, your excellent bill won't fix the root cause of the problem. Thank you very much for this hearing. Thank you for passing the excellent bill out of committee.
Thank you, Mr. Jones. Ms. Garcia, you're now recognized for 5 minutes.
Mr. Chairman, thank you so much for having me. Actually, we're coming up on our 2nd anniversary, and you're welcome to join us at our rooftop party. In the meantime, my written remarks and planned remarks have already been submitted for the record, so I thought I might take the time allotted to me to address some of the issues already raised by the committee, if that's possible. Mr. Chairman, you did an excellent job of laying out the land of FOIA. There are a lot of, an article went out last night that's going viral right now, and inviting 25-year-olds to come and watch how their government works. They're learning for the first time that they're entitled to public records under the law. It's like crazy. So I definitely appreciate you laying out this sort of parameters of the law. One thing I would clarify is that of the 9 exemptions that are listed in the FOIA statute, only 6 of them are discretionary, 3 of them are exclusions. 3 are, according to the law, you're not allowed to have these records, but 6 of them are discretionary, which means that agencies are not compelled to conceal those records. They actually have some judgment and can say, you know what, maybe we'd like to keep these back, but honestly, it wouldn't hurt. Let's give them out. Right now, the agencies are treating them as de facto exclusions, so all 9 exemptions are now being withheld. To Mr. Cummings' point, the ranking member, I'm afraid I would dispute the records, the numbers that are self-reported by the agencies. The full-time employee rate, although it's gone down, it's been far surpassed by a spike in contractor workers replacing government employees. While they shouldn't, according to the Federal Acquisition Regulation, be performing inherently governmental functions, in many cases they are. I've actually requested the records, and even something as small as CBP is paying $250,000 per staffer outside of the government employment environment. So another thing that's actually causing a spike in spending and request, Mr. Cummings raised the issue of requests spiking under the Obama administration. It's actually, I think Amnesty is responsible for the spike in requests. There is a league of immigration advocates who have encouraged all individuals who would like to be approved for amnesty to file a FOIA request seeking their record, their file, their immigration file, and this is actually singularly responsible for that spike in requests. To go on to whether agencies are punishing FOIA officers, I actually think it's the reverse, sir. It's actually the case that the FOIA chief that was in charge at the IRS over the time of Lois Lerner delaying release and not knowing where the records were, in fact, that person has been promoted and is now in charge of withholding Obamacare records over at CMS. And so they're actually rewarded for keeping the government secrets rather than punished for not leaving them out. And those are pretty much the issues that I wanted to raise. In my written remarks, I raised the issue of fees also, just like Mr. Jones. The idea that the regular American citizen cannot file a FOIA request, that you have to be somebody as big as the AP or Bloomberg, it's just unacceptable. OGIS right now doesn't, it's where records requests actually go to die. So in a sense, I'm like the citizens OGIS. I don't have a big dramatic story to tell you that I don't get the records, because I actually do get the records without going to court. And one example is one I got for Pro English, where they were able to get the records of Obamacare being promoted in languages other than English. But getting back to OGIS, they've actually been tasked, their enabling authorization legislation tasks them with providing agencies with procedural guidelines so that they can actually improve their FOIA requests. 4 years later, the Government Accountability Office did a report and found that, in fact, OGIS wasn't doing that at all. And so if it hasn't done what it was initially established for, I'm not sure why we should trust it for more responsibilities. And lastly, with regard to the continued treatment of DOJ as the FOIA cop, I think I heard earlier today. In fact, as was pointed out by Mr. Silver, DOJ is actually the litigator that fights to the death all these FOIA requests. And so I think it's quite a conflict of interest for them to position themselves as the leader in the FOIA world. And in point of fact, the courts have told them they are not. There is no single agency responsible for administration of the FOIA under the law, according to Administrative Procedure Act. And so DOJ has positioned itself that way by hosting trainings where they teach FOIA officers across the federal agencies how to avoid fulfillment of FOIA requests. So it's DOJ that's positioned themselves that way. We continue to give them that credit because they bamboozle media, unfortunately, into believing that they are the FOIA chiefs. And it just sort of becomes a circular process. So those are my remarks. I'm happy to answer any questions. Thanks.
Thank you. Appreciate it. Mr. Rotman, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Cummings, and members of the committee. Thank you for inviting the American Civil Liberties Union to testify today on the Freedom of Information Act. The ACLU believes that the right to know what the government is doing in our name is a necessary corollary and prerequisite to the exercise of our First Amendment rights to freedom of speech, press, assembly, and petition. We simply cannot enjoy these rights to the fullest extent of the framers' intent without an informed populace. The Freedom of Information Act should be, but often is not, the most important tool in guaranteeing this right to know, and we applaud the committee for holding this crucial hearing. As detailed in our written testimony, we offer a number of reforms that could easily and quickly be adopted and that would improve the process for users and government agencies alike. For instance, Congress could mandate the creation of a government-wide portal that would provide users with a one-stop shop for the submission of FOIA requests to any agency or agencies, that would track all requests and that would allow requesters to easily check the status of their requests. Congress could require the posting of all released documents online in an easily text-searchable format and require agencies to store electronic documents, including emails, also in an easily searched format. Congress should clarify that agencies may not falsely issue no records responses when, in fact, records exist but contain sensitive law enforcement material, or the existence of those records is classified, and the records are therefore subject to the exclusions of Section 552C. In such cases, agencies should not lie, but should simply offer what amounts to a GLOMAR response. That is, they should say, quote, "We interpret all or part of your response as a request for records that, if they exist, would not be subject to the disclosure requirements of FOIA pursuant to Section 552C, and we will therefore not process that portion of your request." Importantly, Congress should resist the creation of new exemptions to FOIA, such as that proposed in the Senate's Cybersecurity Information Sharing Bill, which is currently pending in that chamber. As others have noted, Congress should pass the FOIA reform legislation, which is currently pending in both chambers, which would create the portal I mentioned above and would codify the presumption of disclosure absent foreseeable harm, which is currently applicable in the agencies through executive directive. Congress should also reintroduce from earlier versions of the bill a balancing test for Exemption 5, which would allow agencies and the courts to order the disclosure of records covered by Exemption 5 privileges or the work product doctrine if in the public interest. And relatedly, Congress must address the growing problem of secret law, which is anathema in a participatory democracy and is epitomized in secret court opinions permitting, for instance, the wholesale collection of telephone metadata under foreign intelligence surveillance laws, and the Office of Legal Counsel opinions authorizing torture and targeted killing. The Freedom of Information Act and our open and transparent system of democratic government is the ultimate safeguard of our essential freedoms. This notion was at the very heart of Congressman John Moss's decade-long fight to pass FOIA almost 50 years ago in 1966. Indeed, on the floor of the House during debate over the measure, he made that clear. Information about government, he said, is as basic to the intellectual diet as our proper seasonings to the physical diet. Our Constitution recognized this need by guaranteeing free speech and a free press. Mr. Speaker, those wise men who wrote that document, which was then and is now a most radical document, could not have intended to give us an empty right. Inherent in the right of free speech and of our free press is the right to know. It is our solemn responsibility as inheritors of that cause to do all in our power to strengthen those rights and to give them meaning. Our actions today in this House will do precisely that. And it is in that spirit that I thank the committee for holding this essential hearing on how to further strengthen those rights through an improved Freedom of Information Act. Thank you.
Thank you. Ms. Wiseman, you're now recognized for 5 minutes.
Mr. Chairman and members of the committee, I have spent many, many years fighting for greater public access to records that show the public what our government is doing and why. And despite its flaws, I continue to believe the FOIA offers the best tool we have for this purpose. Like Mr. Jones, I do not agree with some on the earlier panel that suggested the FOIA is broken. That said, however, the statute as currently written definitely presents loopholes and limitations that opportunistic agencies have used to circumvent its underlying disclosure purpose. There are steps this committee and Congress as a whole can take to make the FOIA better, and I think they start most significantly with passing the FOIA Oversight and Implementation Act of 2015, which enjoys rare bipartisan support, and now, Mr. Chairman, boasts another important champion in you. The current situation cries out for the kind of meaningful and robust reforms in this legislation. We've heard a lot today about Exemption 5, and I echo those sentiments, that Exemption 5 is, I believe, the most abused exemption that is used to block public access to a wealth of information. In litigation that I brought when I was at Crew against the Department of Justice, DOJ went so far as to argue it had no legal obligation to produce a single OLC opinion, even those that provide the definitive position of the executive branch or a definitive statutory interpretation that all agencies must follow. Exemption 5 has become the catch-all to withhold virtually any records agencies fear may result in embarrassment or unwanted attention. And the FOIA Act addresses this problem, by excluding records from Exemption 5 that embody the working law, effective policy, or final decision of the agency. I think this will avoid the very harm that Congress thought it was legislating against, the accretion or development of a body of secret law, something that has been widely criticized across the political spectrum. I also agree with Mr. Ottman, too, though, that the bill should go further. It should include a provision that was introduced last year that would add a balancing test, and here's why. Well, I would certainly support efforts to get rid of the deliberative process privilege altogether. I don't think that's a very realistic outcome. But in the discovery context, if you are a litigant and you want information that the government is claiming is deliberative process, you get to argue to a court that your need for that information outweighs the need of the government to keep it secret. And I believe by importing that test into the FOIA, it would provide the public and representatives of the public, such as those on this panel and the previous panel, to at least be able to make the argument that the public need for the information outweighs the government's reflexive invocation of the deliberative process privilege. So I would urge the committee to go back and consider adding in that provision. I also agree that by codifying the presumption of openness will go a long way. Right now, we have what I would call is just an aspirational goal, and agencies are free ultimately to do what they want. I think if we want to have the kind of transparency that President Obama committed to, we need that codification. At bottom, I think agencies need to understand that FOIA matters, not just as a statutory command, because it serves a critical role in preserving and advancing our democratic ideals. I have been privileged to meet with many visiting dignitaries and government officials from emerging democracies, and I am struck again and again by how they express the belief that by passing a similar law in their countries, that is the only way that they will have a guaranteed right to have a democratic form of government. Sadly, in our country, however, too many agencies have lost sight of the importance of this right in our own governance. Instead, they view their responsibilities under the FOIA as a burden and a distraction from their primary missions. I think this Congress, through legislation like the FOIA Act, needs to send a very clear and unmistakable message that FOIA still matters and FOIA remains at the core of every agency's central mission. I would be happy to answer any questions that you have. Thank you.